Head into the unknown, down the rabbit hole, where it stops no one knows. We're going head into the unknown. Na, 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 na.
Hi, everybody. Happy Monday. And gosh, we have to start off the week with a bang, don't we? I planned on coming on here today to review the charges and go over some of the things I think about that. So we will do that, but we're going to, of course, touch on what's happened today. So welcome in, everybody. First and foremost, thank you for being here. Hi, Danielle. What's up? Journey Takes a Trip. Hey, Chelsea. Hey, Lisa. Hi, Sniper. Hi, Ava. Unindicted co-conspirator. What's up, Richard? Lodger. Hey, Kim Sleuthy Goosey. Hey, Mace Mama. Twisted Gemini. What's up, Diamond Eyes? I love an early start. I was like, well, I'm here. You guys are here. Let's just go. Let's just do it. Peace. Love, give me peace tonight because WTF. Hey, Caitlin. Hi, Carla. The Royal We. Oh, you're back to the Royal We. I like the Royal Wheat. So an FYI, speaking of wheat, just because I have to, for members, there is 2 new emojis. I don't know if any of you guys that are members can throw up the 2 new emojis. I think that you guys will appreciate them. And anybody who's been following this case definitely will probably be using them in excess. IBR. Hi, ATS. Did I say hi to ATS? No, I don't even know who the hell I said hi to. Hi, Mother of Dragons. Trinity. Hey, Petunia. All right, let me get down here. Hey, Teresa. AKW, woohoo, 11 months. Holy smokes. Hey, Peppermint. Hi, Adrian. Adverse witness. Again, no hearing for issuing a ruling. Just don't even. AJ, hey, Jen. Retaliation, just like when she was offended at the motion to disqualify and chose to order the clerk to strike multiple filings from the docket. This is so crazy. But wait, there you go. But wait, there's more. Hi, Judy. Yeah, there you go. You got the 2 new ones here. I can't see them on my end. It pops up with just the name of them, but I figured you guys would appreciate those, so I threw those in there for you. I need, you know what? Before we get started, let me just give me a hot second and let me see if I can figure this out real quick. And if I can't, then I'll just figure it out later. There's supposedly a way that I can gift memberships. Now, how the heck I do that, I don't know. Giving? Let's see what giving is. Nope, we're going to do that eventually. We're not doing that right now. I have a cough drop in. I'll probably have another one. I brought my whole bag. Because as soon as I think I feel better, I don't. Now, let me go back to you guys. Do you guys know? Hi, C-Dub. Hey, Teresa. Hey, Snappy Dragon. They do. But wait. Oh, hi, other Teresa. All the Teresas are in the house. What's up? Hi, Grace. I'm going to need the whole bag. I know. Yesterday, I was like, I think I feel great. And then by last night, I was like, nope, I'm done. And on all day today, I've been a disaster again. I don't know what it is. Anybody that's a creator in here, do you guys know like a quick way I can just go in? I want to gift some memberships, but I don't know how to do it yet. So if there's a creator in here that knows how to do that, just hit me up. Let me know. Let me know in the chat. I don't want to sit here and Google it and stuff, but if you guys already know how to do it, otherwise I'll do it later. Because I want to gift you guys some memberships because you guys are awesome. What's up, True Crime Crazy? I love to care. Hey, Chris, but I don't want to hear the word wheat ever again. Oh, Queen Elizabeth, I'm so sorry. It's totally going to happen. I can't let it go yet. I have to. I'm going to say it. I know I'm going to do it. So I don't want to make you any promises because it's going to happen. Okay. So we'll start on what we've got today. Oh, thank you, Caitlin. Sophistica, what's up? Hi, Lilith. Hi, Starlight Ann. Hey, Mar. Hey, Moonlight. Okay, we'll just start with this. If anybody that's a creator is in here and knows how to do it, just let me know. Oh, here we go. I think you just hit the $ through YouTube and pick gifted memberships. Oh, okay. So I don't have to do it like in the studio. I can just do it right on here. Okay, hold on. Membership gifting. Oh, here it is. Okay, I can gift 5 of them. Did it do it? It did it. Oh yeah, okay, so that's super simple. Sweet. No, yeah, you just hit the $ on YouTube. Okay, I thought I had to do like something funky in the back end. All right, there you go. So there's 5 memberships just because you guys are awesome. Thank you guys for being here. I know Sleuthy was working on getting the docs for this, but I mean it's essentially on my case, so we'll start there. And then there's a couple other things with docs that a lot of people have reached out to me and commented about some new docs that were released. So I'm going to touch on that because they're not new, but I want to let you guys know that situation. Okay, let me go back over here. Welcome to all the new members. Oh, Cal, you gifted 5 too. Thank you. Sweet. All right, let's turn it green, baby. Let's turn it green. All right, let's share this bad boy. So, anybody who's a little bit behind on the case, let me just fill you in. Oh, you can see my bag of cough drops. There it is. That's so nice. Anybody who's a little behind, so on Thursday, we went to the Supreme Court. They did their oral arguments, and the Supreme Court did an order literally with like 3 hours and 45 minutes. They were like, nope, this is what's going to happen. Hi, Ruckus. Hey, Tony. Hi, Ben. Hey, Sees Through. They immediately were like, nope, we're going to put the attorneys back on. Like, the one thing was like, get the case back on track. Get the case back on track. Let's get this done as quickly as we possibly can. And then, but she denied the request for the 70-day speedy trial, which we assumed she would just because they can request that at the trial level. Once they're back on, they can just go, okay, this is when we're ready. We want a trial within 70 days of now. So they'll be able to submit that whenever they decide to do that. I have my opinions on that, but everybody knows I am not a lawyer. I just have a degree in criminal justice and some forensics, but I'm not a lawyer. So when I read through this stuff, it's my interpretation of the documents based on my knowledge and what I know. Now, could I be wrong? Of course I could. Am I okay with being wrong? I try not to be because I don't want to put out bad info. But I mean, it happens sometimes. So if I am wrong on something, I'm happy to correct it. But just remember, it's just always my opinion, and I'm not a lawyer. Like Harvey always says, he is a lawyer. I'm not one. So just preface that. Maybe I should put like a little disclaimer. So they deny the 70-day, and they also deny having Judge Gull removed. Now, there's been a lot of speculation on why those were denied. I gave you my speculation on the 70-day one. I didn't think it would have anything to do with anything to begin with. What the Supreme Court does is they write an opinion. And so even though there is an order, the order states Baldwin and Rosie come back. And then they will write an opinion that will tell us why they decided that. on each count, why they decided legally, why they decided to reinstate them, why they decided to deny the 70 days, and why they denied Judge Gull's removal. Now, there could be a lot of reasons why. So literally anything that anybody says at this point is going to be pure speculation, unless they're just really adamant on Supreme Court law, an Indiana Supreme Court, like what they would typically do with the other part. But hi everybody that just popped in. I'll read your comments just a second. And thank you, Scott, very much. I appreciate that. So we're waiting for the opinion to be given by the Supreme Court so that we can understand why they made the decisions that they made. So right now it's just kind of this is what we think. This is why we think it. This is why we think they did what they did. My assumption is that they believe that both of those can be done at the court level, like at trial court level. It's not necessary for the Supreme Court to have to step in. There's been a lot of back and forth about why Judge Gull could stay, and they could also bring back Baldwin and Rosie. And like, what kind of conflict is that going to create? Does it have a perception of bias? Does it, what is it? What's going to happen with that? Obviously, my hope was, and I think a lot of people's hope was, that they would just go back in. We could just get moving, and everybody could just take a breath, get out of the emotions, and go in the courtroom and do what needed to be done on the professional level. There's also been the talk of, will she just come in and recuse herself? Or will she come in and do something retaliatory? Will she come in and be professional? Also vice versa. Will they come in and just be professional and just get through it and see what happens? And just, file for this speedy trial. Let's get Richard Allen to trial. Let's go for it. So a lot of speculation on what was going to happen there. We also know that on the day of the Supreme Court, that Nick McClelland filed to have Richard Allen's charges amended. Now, I want to make sure it's very clear. He filed to have them amended. They are not amended yet. That doesn't mean they won't be, because the chances of them being amended is probably very good. Which is why we're going to touch on some of that today. So, because I hear a lot of things that I do know, even though I'm not a lawyer, I do know are being put out there incorrectly. So we're going to touch on that after we go through this part. Where was I at? What the hell? Okay, so let me share this with you guys. So right out the gate, we have on Friday, we have that both Baldwin and Rosie filed their appearances back to be public defenders for Richard Allen. And we knew that something was going to end up popping off this week. Well, we just didn't really know how far anybody was going to take it. I was kind of thinking they would wait for the opinion from the Supreme Court to see, okay, well, this is what they said, why they wouldn't remove Gull. This is why they said, XYZ, whatever way it was. So I was thinking they would wait for that to come out. They might file like some of their other stuff, or ask to have the other motions resubmitted or refiled, or whatever the terminology would be for that. Hi, Jen Liu. Hey, Stephen. And see, I say hi to you guys, and then I totally lose what I'm talking about. So I thought that maybe they would just go, okay, yes, we want to have the Franks motion. We want to have the Franks hearing. Yes, we want to have the motion Limine about the ballistics on the bullet, which is essentially just saying we want to suppress that evidence because we think it's no good. We think it's bad evidence, and that the motion Limine just says, hey, we want a hearing to prove that it's bad evidence and get rid of it. So it can't be brought in a trial. Then they so I figured maybe those two things would happen. There was some speculation on whether Judge Gull was just going to decide to recuse herself. I think somebody just brought it up in chat. Like, was there some type of backdoor offer, kind of like how she gave Baldwin and Rosie, of, hey, can you, like just go away, and we won't do this publicly. We won't have it written in the Supreme Court order, but just obviously there's the perception of bias. I mean, I forget that we're not the whole world, you know, as much as we think we are, we're not. And I know that there are people who are absolutely supportive of her and the decisions that she makes. So by all means, just, it is what it is. But I mean, you cannot say that there is no perception of bias, because there is plenty of us that do see it. And now I'm wondering if anybody else is going to see it again today, or more, or open their eyes to it, or whatever you want to call it. Real quick, somebody asked if B and R are definitely death penalty certified. So Rosie is death penalty certified as a first chair. I believe that Baldwin is certified as a second chair, which is okay because he is the second chair. I'm not 100% about Baldwin. I know that what's happening is there's a web page that's being passed around for people to look at it and see that they're not listed on this death penalty certified website. Well, there's two things behind that. One, it's a public defender website, which is okay. They can still be on there. But two, if you are looking at that website, make sure you read the disclaimer at the top. It tells you that not all death penalty certified lawyers are listed on that page. They have to request to be listed. So from my understanding, both are, and Kara said the page might be out of date, but they don't have to, but they don't even have to be on there. It's, you request to be on there. So it's fine. So we can kind of go in. You want to talk about that just for a hot second? I don't think he's going to go for the death penalty anyway, but we'll talk more about that when we get to the charges. He may say that he wants to try it, but I mean, I don't know. Well, like I said, we'll get to that. So let's talk about today what happened, what she goes in and files and says. So she says, the court, having had defendant's motion for a Franks hearing filed on September 18th of 2023, the memorandum in support of the accused motion for a Franks hearing filed on September 18th, 2023, and the defendant's supplemental motion for Franks hearing filed on October 2nd, 2023. Defendant's additional Franks notice, also filed on October 3rd, 2023. The state's objection to the defendant's motion to suppress, which was filed in June. That's the motion in limine that's wanting to suppress. And they remember, or that's when they went in and they were like, she was like, well, you're going to have to do a Franks motion, and then we'll discuss it. All right, hold on. Let me see what you guys are saying in here. Let me see. Hey, Queen. What happened to the motion to recuse? Okay. So, hey, other Teresa's here. So they had gone in with the motion to suppress, and she was like, yeah, you know, you guys are going to need to do a Franks motion. So, and the state's second objection, defendant's motion to suppress filed on September 25th, 2023 under advisement, now denies the defendant's motion for a Franks hearing. The court finds that the affidavit, which is the probable cause affidavit, submitted in support of the issuance of the search warrant. Now, this is where we're going to talk about this document, where people think this document is new. It is not new. It's just hidden in another document. So I think that's where the confusion is coming from. The affidavit submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the murders would be found in the defendant's home and vehicles. The court does not find that the affidavit submitted false statements, or that the affiant, which is would be Tony Liggett, omitted statements with reckless disregard, nor does the court find that the affiant intended to mislead the judge by failing to present information. As the court has found the affidavit for issuance of the search warrant was valid, the search itself was reasonable and legal under Indiana law and Fourth Amendment case law. Defendant's motion to suppress, fruits of search of 1967 North Whiteman Drive in Delphi, filed on May 19, 2023, is also denied based upon all the pleadings, the memorandums, and exhibits previously submitted in support of the request for a Franks hearing. So let's just dumb this down for just a hot second. Essentially, they go in, they say, we want to suppress this evidence. They file for that back in May, June. So they go in for the hearing. They're saying, hey, we want to suppress this. The hearing ends up essentially being more about Richard Allen's rights in prison. And she says, we'll move the motion to suppress, to another date. And what we really want is for you guys to write up a Franks motion. And then we can have a hearing to decide whether what you're saying is accurate or not accurate. That's where it stood. Then on September 18th, give me 1 second, you guys. And then on December 18th, they file what everybody now knows as the Franks memo, Franks motion, Franks memorandum, whatever one you want to use, which you call it the Franks. So they file that, and shit hits the fan. Everybody's just like all over the place. It's all everything goes crazy, and we know the sequence of events pretty much after that. On October 19th, she calls him back to the office. We have the transcripts. If anybody hasn't read through them, I have a live reading through them. I can also pull them up when we're done going through this if you guys want to review it. But she tells them that she hasn't even read the Franks motion, the Franks memo. She has not finished reading it. On October 19th, she has not finished reading it, much less gone through the hours and hours and hours of evidence that was attached to it. Because remember, they attached so many exhibits that had interviews of different people for her to have to go through. And she said, I haven't done that, and I haven't even finished reading it yet. On October 19th, they recused, or they say they're leaving. There's all the shenanigans. We all know about the shenanigans at this point. So on October 19th, she hasn't finished reading it. She puts in 2 new attorneys. She tells the 2 new attorneys on October 31st, or there right around then, that if you choose to adopt the Franks motion, the Franks memo, and you want to have a hearing, we will schedule one. But you have to basically choose, you have to choose to adopt it, and then we'll have a hearing about it. So they're going to have to choose to adopt it. They would have had to have rewritten it however they wanted it done, or just said, hey, no, this is exactly what we want. So we're just going to go forward with this. And then she tells them she's going to have a hearing on it. So remember, October 19th, she hasn't finished reading it yet, hasn't looked at any of the exhibits. October 31st, she's like, you guys want to adopt it, let me know, then we'll schedule a hearing. Then we fast forward, January 18th comes. There has been no submission by the other 2, Scrumman and Librato, stating that they want to adopt it. Also nothing stating that they don't want to adopt it. Nothing's happened with it. It's just sitting there stagnant. Old attorneys get brought back in, and Friday they file their appearances. Monday she says, look at what I did this weekend. I read the memo. I read the whole memo, and I looked at all of your hours of evidence that you guys provided. There's no way somebody is going to convince me that she sat and read that or looked at all the exhibits that were attached to it when it wasn't even a motion pending in front of her any longer. Thanks, Sarah. It doesn't even make sense. So she didn't read it from September 18th until October 19th. Couldn't even finish reading 136 pages. Didn't finish reading it. But then she gets rid of them. And then she's like, now I guess I'll sit back and read it. What? Come on. Does anybody really believe that? Do you guys think that she actually found out on Thursday that they were back on, and she was like, let me read it right now and then we'll make a decision? Gosh. So why not have the hearing? I don't know. It's just, this is the whole thing about the perception of bias that I struggle with. There was no reason to not have the hearing. They provided enough to prove that there was things that were omitted. Now, I've said from the beginning, with the search warrant, and what they said was quote unquote lied about or omitted or anything, you know, that was exaggerated or however you want to look at it, that Tony Liggett put into the search warrant. If you essentially take that search warrant and you took those things out of it and you gave it to the judge that way, would the judge still sign the search warrant? And I do believe a judge still would have. I do believe a judge would have signed it. I think that they had enough, regardless, even if she said that she saw the guy walking and he was muddy and he looked like he'd been in a fight, without saying the word bloody. I think that there's something to that. I think that with the other girls saying that they saw somebody, so I think there's enough to say, yeah, you can search. You can go ahead and search like that. The burden is not as high as I think that we want it to be, because we're looking at like the conviction of him. So I think with even taking some of that out, I think there would have been a search warrant regardless, which would lead to that there would still be this bullet, there would still be this gun, there would still be those the types of things. Now, I have a whole nother feeling about Liggett that we can go into in a minute, but okay, so we're going to finish this. I like I said, for me, this is out the gate. She doesn't rule on any of this shit for months. Doesn't rule. But right out the gate on Monday, she's like, let me just tell you what I'm going to do. Welcome back, boys. Here's what we're going to do. So they'd also, the defendant's motion in limine regarding the ballistics, which they filed in June, is reviewed and denied without a hearing. Okay, if it was that simple and it was so easy to review it and deny the hearing, why the fuck wasn't that done already? This is true, yeah. We'll touch on that too, because we're going to touch on the search warrant as soon as we're done with this. It does, right? And that's the problem with it. That's the whole issue. Is you can't have it looking that way to the public, especially like Gull. I do not think this woman is a stupid woman. I really do not. This whole, like, the world is watching, you know, like, anybody who is interested in law, anybody who's interested in true crime, anybody who lives in that vicinity, they're all paying attention to what's happening right now. And I don't mean like every single person, but I'm just saying, like, there is a shit ton of people, and there's people across the whole world that are paying attention to see what happens and what our court system is like. And I know that, like, people from Indiana are going like, oh my God, like, this represents where I live. And so she just decides all of a sudden today that there's not enough in this motion in limine regarding the ballistics, and she's just like, okay, I can deny it now without a hearing. Couldn't do that all that time, but now she can. The court finds the evidence contained in defendant's exhibits A and B attached to the motion is relevant and admissible. So remember, that has to do with the motion limine regarding the ballistics. So this is what they put forward to show that. So she's saying that the evidence, the exhibits that you brought, yes, those will be okay, and they will go forward. They can go forward to trial. You will be able to use them at trial. The court finds the evidence contained is substantially outweighed by its prejudicial impact, and that the evidence will not confuse or mislead the jury. Defendant's motion to transfer, which is now another one that is current and is up for from Librato and Scremin, mostly Scremin, to have him transferred out of Wabash, is to move him to a jail, not a prison. So taken under advisement pending the state's response, and if any, then a hearing would be set. The state's motion, so now remember, on the 18th, McClellan filed to amend the charges, will be set for a remote hearing. So they will be having a hearing on why he wants to amend the charges. So my big question when it comes to some of this is, because if Baldwin and Rosie were removed, the other attorneys would have had to have adopted the motions that were still pending. Now they come back, so all their motions are just automatically reinstated. And this is where the whole I'm not a lawyer comes in, because I don't really understand how that would work. And if it's ruled that they were essentially unconstitutionally removed, that would also mean to me, this layman over here, that the motion for her to be removed would also still be there. And if that motion is still there, then she's not allowed to rule on any motions until that motion is done. Now, is she going to act like, well, they put that on there when they weren't the attorneys? Because I don't know. I mean, this doesn't make any sense to me. Hi, Jules. Typically, a judge will allow a prosecutor to amend charges, but the timing just feels suspicious. I absolutely agree. There's really not going to be a good reason that she wouldn't amend the charges, because it's not uncommon. The problem, once again, is now just going to come to the perception of the timing of the whole thing and how it's just really wonky. And if they had been in trial like they wanted to be on January 8th, there would be no January 18th removing or amending any charges. So is she gonna just continue to act like that motion doesn't exist because they weren't attorneys on record at the time, even though they were attorneys on record, and she just struck them from the record, and now the Supreme Court has ruled that she unconstitutionally removed them, essentially? So those are my two big questions. How can she make these decisions? The only thing that would make sense to me is that if they come back, any pending motion would be totally open in full force. And if that's the case, then I would think that one would still have to be there. I have no idea where Bob is. I can text him. He might be. He's probably going to be doing a live on this soon, I would think. He's going to have lots to say. So maybe we'll just listen. Okay. Hold on. Or I would assume that anything that they had pending would be gone then, and they'd have to resubmit it or say, hey, we want to reopen this. And there'd have to be some type of communication stating that. I'm sure he'll have a lot to say. I'm sure he will. So that's kind of where I'm stuck at. Is she even allowed to rule on these? Is she allowed to just act like the other motions are not there? Is she ruling on these and then saying, nope, these are done and then I'm going to bounce? Because that doesn't make sense. Somebody mentioned this earlier too. I think it was Sniper, and I absolutely agree. I absolutely agree that I cannot understand why she would stay. I mean, judges recuse themselves for so much less. And here's the irony is, Baldwin actually has another murder case now that he picked up recently, and it's in front of Judge Gull. So, this isn't going to be his only rodeo with her. I just don't think there's... I mean, if I was the client And I knew any of this history, and I went in and I was like, wait a minute, you're my attorney and you're my judge? I'm fucked. Like, that would be like the first thing I would think of if I had any indication of any of this history. I want a different lawyer. I want a different judge. I want a different court. I want it all. So, okay, so let's talk about the search warrant. So there's a few, like I said, a few people have contacted me and saying like that somebody apparently had put out this unredacted search warrant that is somehow new. It's not new. It has been out. It's just hidden in other documents. So the state's objection to the defendant's motion to suppress. And they put, so this is what she's talking about, FYI. You guys can't see this, so give me a second. Let me make it bigger for you. We've gone through this a couple of times, but we probably don't. It's hard because there's so much document. There's so many documents. Hi, everybody that just popped in. But this is the search warrant. So in this document where the state is objecting to the defendant's motion to suppress evidence, they put a copy of the search warrant unredacted. This is one of those that we used when we were talking about the fact that there are public documents that name in full the girls who, remember, she was mad that the Franks motion named the girls. And then it also names all of the witnesses without any retractions or without any redactions. So this is the affidavit for the search warrant. It's just hidden in other documents. So unless there's a totally different document that somebody's talking about, I don't know. I don't know. This is what I'm being told is now being discussed. So I just said FYI. Obviously, going over it at any point is always a good refresher. So it's not a bad idea to go over it. Just, it's not a new document. It is there. She said actual. Hold on. She says the actual warrant was in there, and that's why it was made confidential. Which part? In this one? Yeah, well, because I think that it's there's like 3 different documents that kind of go over the same info. Some are redacted, some are not. Some have a little bit of additional information. And then if you throw in the fact that we got Ron Logan's around the same time, I think it all kind of gets like meshed together. But they're all different technically. They're all part of different documents. I wish some YouTubers would reuse themselves. Hi, Johnny. Hi, Delana. Okay, I think it goes higher. Doug Carter. Well, Doug Carter isn't. I don't think he should not have any influence over a judge. But who knows? I have no idea anymore. That's just all conjecture and speculation. And there's something wrong. There's something that just goes like red flags, literally all around it. But who's tied in and who's part of everything? It's a fucking disaster. I'm here but late. Hi. All right, let me see. Let me see what you guys think. I feel so misled by Carter. Why is the actual warrant confidential? Yeah, no idea. Because they hid the warrant in this document anyway. So probably because they're not actually reading through what the documents are. They're just saying, like, oops, like, here, just put this one out. Oh, this is just if you look at the name of the document, like I said, it's literally state's objection to defendant's motion to suppress. So if they're like, okay, yeah, that one would be fine to go out. It wouldn't have anything in it. Click. That one would be fine. Click. And then, oh, crap, wait a minute. We didn't go through and see everything that was attached. Everything that was attached to that document. So it's here But like I said, I mean, it's always worth going over because, especially because it's now coming back up as something that is tied in to what's going on today, which is her saying your motion to suppress denied. This is the state's response, asking her to deny it. So we could look through it again if you want to. I don't think there's anything in here that's like bombshell. Because like I said, we've gone through this a couple times. But just FYI, that's what that is. So I think she's sealing stuff. She was sealing stuff as confidential based on what the title of the document was instead of actually paying attention to what was in the document. So yes, this search warrant on its own, you cannot have. This search warrant hidden in other stuff, you can. Who knew? This is also the one that has, like everybody asked, have we seen this? This is also the one that goes over everything that was taken from his residence and the car. Oh, FYI. So if anybody's looking for that, that's where it's at. But it's hidden in this document. Okay. Let me see what you guys are saying. The FBI and the religious studies professors take the stand. Did you see where she let the guy go without jail time after he admitted to doing bad stuff with his adopted daughter? I did. I heard about that. I did not see it. Is she reading anything? It's just all willy-nilly. She's like, yeah, put this one out. Deny this one. Let's have a hearing on this one. Plays a little Rochambeau. Some Odinite paper scissors. That's what she plays. I am surprised she's still digging in and not reassigning this guy. I don't know. Maybe she knows something about the opinion that we don't. That's why I was saying the opinion is really, really important for what reasons they denied removing her. Is it simply, hey, attorneys, you want back on the case, then you deal with it and refile to have her removed? So if they refile, okay, so let's play that out. If they file and they, okay, well, I guess we have to kind of backtrack that because we have to play out the fact that it was already actually submitted as a motion and she removed it, but she did put it back on with the first original action that was filed with the Supreme Court. She puts it back on but says doesn't matter, which is, it is what it is. But now that they were never supposed to have been removed, does that even count? Probably not. So she's like, let me deny all this other stuff before they can resubmit a motion for me to leave. Now, I think that's the only thing that makes sense to me then is that she's going to say, nope, you guys weren't the attorneys at that time. I had removed you as of the 19th and you didn't get to submit it. So I can still decide on all these other motions. So now if they put in the motion for her to be removed, she wouldn't be able to do anything else. She wouldn't be able to decide on anything else. Then she's the one who has to say whether she's going to leave or not. So then she would have the option that she just can say, I recuse myself, or she would say, no, I'm going to stay here. They would either have to accept the fact that she's going to stay there, or they'd have to file it with the appellate court as an interlocutory appeal and say, hey, we need this. That's basically an appeal that needs to be done faster. When we were talking about the Supreme Court stuff, that's what they kept trying to suggest Baldwin and Rosie should have done, but they couldn't because she had taken them off as counsel of record. So they couldn't file anything like that. So now that they're back on, they file with her. She says no. They have to go to file the interlocutory appeal and say, go to the appellate court, and then they have to get the appellate court to say, you have no choice, Judge Gull, you have to remove yourself, and we're going to replace you. Now, that's going to take some time. So do they go that route, or do they go, we want a trial? So they cannot file, I mean, I guess they could, but they just wouldn't file to have a speedy trial within 70 days and then file for her to be removed, because then the defendant is the one that's that's postponing his own speedy trial. So it would make no sense to do, and that's not like they could, it just would make no sense to do that. So they need to get all this other stuff buttoned up first. So they need her to either leave or not leave. Like what? Maybe they're just gonna go with it. Maybe they're just gonna be like, fuck it, we're just gonna go to trial the way that it is right now and file 70 days and be like, listen, we don't have to convince the judge, we have to convince the jury. Now, as a juror, you would have to think that how the judge is treating an attorney in your presence would give you, as a juror, some bias on whether you would like the defense or the prosecution, and that can't be good. So, oh, hey, Bob, we were asking where you were because I had some questions. It tolls the time. Yeah, I had some questions for you. I don't know if you're too busy. I could send you a link if you want to come up, or if you could just answer them in chat, we would probably be very, very grateful. Retired cop asked in the Soto case podcast. In my opinion, Gull is going to stay on and create as much delay as possible to try and save Slicknick's ass. Well, once they file for the speedy trial, she can't really save his ass anymore, but she can still vote in his favor anytime. Or not really vote, but she can still rule in his favor anytime. I'll answer in chat. Okay. So the first question we had was if, I gotta even try to think of how I worded this to make sense now. How can Judge Gull rule on the Franks hearing and rule on the motion in limine when there is a standing motion for her to be removed from the case? Because she shouldn't be able to be making any rulings if that's there. Is there something to that because of the way that the timing of how it was filed, even though she has now, or it's already been ruled by the Supreme Court that the attorneys should not have been removed, hence why they're back on, would that put all of those things back into play? Or because of the timing of the motion to have her removed, she still gets to make the rulings on stuff like this, and now they'll have to resubmit a motion to have her removed? Because, like, how are all these still open and pending, but that one isn't? And if that one is, she can't rule on any other motions. Does that make sense? I'm going to take a drink while we wait for Bob's expertise. The FBI then looked at RL after Liggett and Holman lied to them and said that the professor disagreed with them. I thought that was just standard procedure. I thought she wasn't allowed to do that. That's not? Okay, well I'm gonna have to do some more reading. Is it Hennessy's motion that talks about it? Let me look. It'll pop up if I have it named. Well, okay. But it's not actually the legal answer. See, well, I was thinking this too, Veronica, but I just didn't think it would make sense because of the reasons that the Supreme Court had mentioned, and we don't know what's in their opinion yet. But while they were actually discussing it, Justice Rush says that the one document that she was upset about was actually put out before the gag order. So that doesn't make any sense. And then she goes through each one, and essentially, like, they're left with, you know, him accidentally emailing Brandon Woodhouse a thumb drive map. So I don't know. I don't know. That'd be tough. Her argument would be that Rosie filed it when he wasn't Rick's lawyer. Okay. So this is where I'm struggling, because isn't the order by the Supreme Court trumping that, saying you didn't have the right to remove them? So they were Rick's lawyers? Yeah, Ivy, I remember that too. That's why I'm like, wait a minute, where did that come from then? Because I thought that was protocol. I gotta find Hennessy's. If I don't have it labeled Hennessy though, then I don't. And it's not gonna pop up. No. Sleuthy, if you're here, I know you'll find it quickly. JP. I think it's called the verified supplementation of the record. Let me look. Ariel, you so smart. Hold on, let me see if this is the right one. Sleuthy, I'm looking for the one where we think it's Hennessy that says that she can't rule on anything while there's a disqualification motion pending. Hey, Bushit. Oh, goodness. Have fun with that. Yeah, they're not out. They're not going to have this trial court hold the hearing because there's no way to disqualify a lawyer unless they're not a lawyer of the bar or it's a conflict of interest. Yep. The appearance of bias and the overabundance of appearance of bias and impropriety. Go ahead, baby. Okay, is it in this one? I'm going to mute really quick. I'll be right back. Okay, so the verified supplementation of the record, in addition to the witnesses referenced in the offer of performance, I don't think it's in here. That's the way it is in Illinois. I'm in California. Let me see. It's in the. Oh, it's in his memorandum. It's in his memorandum. Hold on. Let me see if this is it. I think this might be it. Thank you, Grace. Any issues or concerns of reputation should be focused on the Sixth Amendment. Continuity of counsel is critical for adequate representation, must be given consideration. Mr. Allen has developed a strong and trusting bond. Disqualification of either of his court-appointed attorneys would greatly prejudice his right to counsel in a timely trial. Sixth Amendment guarantees in all criminal prosecutions, the accused shall have the assistance of counsel for his defense. The authority to remove appointed counsel is limited and has resulted in reversals in this many cases. Disqualification of counsel is an extreme remedy for any alleged or perceived violation of court's order. Most of it is not. Furthermore, any sanction requires proof. Who snookered? Oh, this is when he was snookered. Which one is it, Ariel? Is it this one? Recusal and disqualification. Is that the one that he cites in here that I just skipped over? Lewis versus State. That's Hannah versus State. Jones versus State. I'm not going to spend too much more time looking for this because I think most of you know exactly what I'm talking about. It just, you know how it drives me crazy that I can't show you what I'm talking about. What would we do? I now wish I went to law school. Okay, the only conspiracy in the case is the one being driven by those who seek to convict an innocent man with bullshit evidence. Yep. Okay. Upon the filing of the motion for recusal and to disqualify, the court loses the authority and jurisdiction to make rulings on other motions or issue orders other a hearing and ruling on the request for recusal and disqualification. But so like Bob said, like she said, that's exactly what I was thinking too, is like she's going to try to say that they weren't his attorneys. So those still don't count, but that's where I'm stuck at though, is if the Supreme Court's saying you didn't have a right to remove them as his attorneys, then everything should go back to pre-October 19th because she didn't have a right to do it the way she did it. So anything that happens, I guess, okay, I guess I answered my own question. If everything goes back to pre-October 19th, then there is no motion for her to be removed. So maybe that's the answer. That's what I was saying too. Yeah. Okay, so out the gate, she just is like, no, I'm going to go ahead and deny your Frank's motion, and I'm going to deny the motion in limine for the ballistics. But if there's no way she read that Frank's motion. It just doesn't make sense to me that on October 19th, she hadn't finished reading it. She had not finished reading it and had not looked at any of the evidence. There was no reason for her to do that when they weren't his attorneys. So they come back on Thursday late afternoon, and now by Monday, she's read everything. And for the motion in limine, she was like, yeah. She's like, I didn't want to rule on that back in June, July, August, September, October, so I waited until January. See, Ivy Rose, see, that's true, because she also does say in that she says that they're going to go, they're waiting for a response from the state based on the transfer request of the new attorney that was filed on January 12th. So okay. I don't know. I'm very confused on that part. So that's where I'm kind of lost at. The rest of it really, it makes more sense, but this doesn't. The fact that she did this right now was to beat the court's order. Well, she had months to do it. She had months to rule on this motion, and she's just like, you know, I'm just gonna take this long, and then I'll decide. She has to catch up. I'm just telling you, there's no way she read that and went through all of that evidence unless she sat down this weekend and decided that was the only thing she was gonna do. Because why would she go through it during the time that she says they weren't his attorneys? Was she like, oh, I'm just interested, or maybe I should just see for myself? I just don't think so. Hey, the unraveling, the fuckery commenceth. that she's not going to listen to anybody, and that we got to be on the offense. Spite. Yeah, that's one word for it. Spite. Okay, so, well, I don't know. I don't have that answer, so that's one that I'll be trying to figure out. Work on the weekend. What you talking about? All right. So anything else we want to discuss about that? Otherwise, we'll go back and we'll start talking about we'll go talk about the charges, and we'll talk about what Kara had to say about the charges. I think so too. A bad timing. Again, like their timing is very interesting. I mean, I don't know how else to say it. Everything they do, I'm just like, why would you do that right now? Anyone know if the state of Indiana went to defend her? I think she had to pay out of pocket. I don't think the state would have paid for it. I don't know that, though. I shouldn't answer because I don't actually know. But I think that she had to pay out of pocket. Once the attorney general said no. But she knew if the court ordered that everything, that it was, if they were never removed, then she would have been foreclosed from ruling on the motions. Well, how do you get it both ways then? How do you get it both ways? She's just going to still act like those don't matter. Well, the pro bono ones don't matter because now they're back on as public defenders, so that, I guess, doesn't matter. She did have to pay. Hi, KO, by the way. Hi, Aspen. We're talking about Judge Gull and her denying the Franks motion and denying the motion in limine for the ballistics. And now we're gonna go on to the charges, but I want to wrap this one up first, before we move on. Now I realize almost all other cases have even less scrutiny. Yeah. The motion was filed before they filed pro bono. Yes, but I'm just saying, she's saying that all of that's just gone. None of those filings matter. Anything that they filed after the 19th is irrelevant to her. But is it irrelevant legally? That's where I'm at. And if it's not irrelevant legally, then is she allowed to rule on these motions when it was stated that you can't rule on motions until the motion for removal is taken up? They weren't his attorneys. So that's just it. So those don't, so it doesn't matter. So if they had filed, okay, now I'm just going to throw this out there and then I'm going to move on. If they had filed this morning or Friday, as soon as they filed to their appearances again, if they had filed to have her removed, then she wouldn't be able to do any of this. We won't know until the opinion. Yeah, so everything that none of it mattered. I got you. I don't think it's possible for them to go back to the way everything was on October 19th. I just don't. The appearance of bias at this point, the perception of bias at this point, I don't know. To me, it's overwhelming. Others are going to be like, nope, she's doing the right thing. So, hi, Wheel B. Hi, Venue. Well, that in her eyes they weren't, which is why she was okay with removing anything that they had submitted. I don't know. I think this is where he's saying like what the Supreme Court writes in their opinion is going to be important, because if the Supreme Court's opinion states that they are just put back onto the case, then you're going to have the whole were they not on, were they on, were they not on. If their opinion comes down to that they were should never have actually been removed, This is why I kind of thought that both sides would almost wait it out a little bit and see what the opinion states and why it states that they made the decisions that they made before there was just any more shenanigans. But she's like, oh, hell no, I'm coming in hot. That's what I was thinking about McClellan's like wanting to amend these charges. I'm like, come on. What do you want, like, Gull to sign off on it before the Supreme Court says that she can't sign off on anything? Like, was he nervous? Why would he wait until that day, a half hour before the hearing? Well, see, that's another point of contention in the eyes of the court, but we need to see the opinion. Yep, that's what I'm saying. I think so too. But they weren't removed until the 31st. Well, according to Judge Gull, they were removed on the 19th when they voluntarily withdrew. This was always a point of controversy because Baldwin said he, quote unquote, orally withdrew, and then Rosie was supposed to file a written withdrawal, which he never did, but she takes both into consideration, saying, no, you guys both withdrew on the 19th, and as of the 19th, you're no longer his attorneys of record. This was where that whole controversy comes in, and I don't know if it's going to get cleared up ever, or if it's just going to be something that just stays in the wind regardless. She tells them, nope, you're not his attorneys anymore. You guys withdrew. They file all these things. She tells the clerk, get them off the docket. They don't need to be there. And then, of course, we know that the Supreme Court tells her that they do. But she just marks that they're not attorneys on record. So they're just sitting there. They don't mean anything. Then on the 31st, or they file pro bono, they go to court on the 31st. They show up on the 31st, and she says, like, what's changed? What's changed? You guys, I found you guys incompetent, or, whatever. I don't remember what word she used at this point. It was all of them. And she says, I can't let you back on. I can't let you back on. So she's not letting them be his attorneys on the 31st. So they weren't, in her eyes, they were already gone on the 19th. But I just don't know. I don't know how much her eyes matter based on the Supreme Court's ruling. Right. Well, he puts in there the unraveling, though, because you remember he does it before they're back, and he's like, they'll have plenty of time. Grossly negligent thinking. They'll have plenty of time to go through. These new attorneys will have plenty of time to deal with the new charges. The state filed a motion for leave to amend. Yes. It's not done yet. She's going to hold a hearing. I'm glad they're back. They're going to fuck up again. I disagree with you. I don't think so. I was really just hoping. Well, he's the one who files the motion for her to be removed, though. So, well, then I was also told that you cannot orally withdraw. It has to be in writing. Like, legally, it has to be in writing. So even if Baldwin did withdraw, and I haven't looked that up myself, so I don't know, but that's what I was told by another attorney, was like, no, it has to be in writing. You cannot orally withdraw. Irrelevant to her, but it's not because they were acting as attorneys. The motion to refuse from the docket was that submitted when they submitted their file to the Indiana Supreme Court. Right. Irrelevant to her. Yep. Lots of power tripping. Louder for the ones in the back. I mean, they in writing with written notice to Rick Allen. See, this is such a clusterfuck. Oh my gosh. They did have to do a written filing. Yep. That's why I'm like, I don't know. And I think that's where everybody keeps saying, like, we got to wait for the opinion. 8:45 Eastern, so 5:45. Okay, I'll be done by then, so I can come over there. So that's 5:45 Pacific, 8:45 Eastern. So we'll be able to ask Bob some questions. And is Allie going to be with you? Because, you know, we're all Team Allie. Yeah, Baldwin's isn't legit either. Yeah, and Rick has to agree. Look at Chad Daybell's attorney. He tried to. That's a whole nother can of worms unraveling. Trying to talking about Chad Daybell and freaking Pryor. I don't even know what that cluster was. No, so Yellow Jacket. I'm going to read the comment first, and then I have something I want to say. I'm glad this which finds police didn't lie, omit info, or recklessly disregard truth without ever talking to them or seeing evidence that they did. So this is what I was saying earlier is how in the world did she even when did she even begin to try to figure out whether any of it was true when she said on the 19th, she hadn't looked at anything. She hadn't finished reading it, hadn't looked at any of the evidence. And now all of a sudden this weekend, she just decides that she's going to review all of it so that she can deny it. But now, on the other hand, she can quickly go through and determine that the defense attorneys were grossly negligent, incompetent, all the things that she thinks that they were, without holding the hearing, without seeing any evidence, just because Nikki Poo says that's what they were, and that they had, you know, I brought my witnesses, and I have all this evidence that even though it's an active investigation, I'm going to go ahead and let you guys see it so that you know that these attorneys are so bad. And she's like, I don't even need to see it. I know they're bad. And she boots them off the case. But now you have like legitimate lies that they are caught in, and you cannot get around it. And she's like, nope, I don't think they did anything wrong. I think they're perfect and I don't need to hear from anybody. Fucking dead. Yes, exactly. Yeah, she just totally make a gross negligence finding on the other side without having to hear anything. Oh, he is? He is a good attorney. I like listening. I like reading his stuff on Twitter. You gonna let him talk this time, Bob? Because you know you get a lot of shit for that. And make sure you hit the live button so you guys don't talk for 40 minutes before you go live. Even though it's fucking amazing and I still love you anyway. Okay, so let's talk. Hey, Deets, because she's worried about what may happen. Yeah. Let's not worry about the fact that we have cops that are lying to get search warrants. Even though, like I said, I think that even if you take all the stuff out that they're saying is quote unquote lied, I still think that the judge would have issued the search warrant. Not to mention it was Judge Diener, and I just, I got thoughts on that guy. So. Okay, so let's talk about the new charges. And then Kara actually did a whole thing for us on the charges. Oh, shoot, I'll leave it over here for right now. So we'll go through them, and then we touched on them the other day. I'll do my best to hit go live. I don't think you'll ever make that mistake again, so I have no worries. Hi, True Crime Fan Girl. If the defense appeals the Frank's denial, does that affect the 70-day speedy trial? Well, it would depend on, they haven't filed the 70-day speedy trial, so I think that this is what they have to do now, is to figure out what's the most important things to do. Do they file to have her removed? Do they wait to have that, heard? Like, what are the more important things to do? Because they don't want to file the 70-day speedy trial and then try to file all this other stuff on top of that. So they've got to make some decisions there and then decide if they're going to file the 70-day speedy trial. How do we know he called the tip line? I've never heard that. It's been speculated. We don't know that, but it has been speculated that he called his buddy that he had known which is where the whole Thomas Skinner stuff comes in, and then that he went and met with Doolin. The state will get by with Allen as BG if the defense doesn't prove that he's not. Well, now they're upping the game, though. They're gonna say that he's everybody, and let the jury pick what they want to believe he is, so they can get him on something. Also, I have some other theories on why I think the charges are high. All eyes on Delphi. He cleared himself very early in the investigation. Somehow, I thought he spoke to Officer Skinner, not Doolin. That's been a rumor. That has never been confirmed, but I know the origin of it. I just don't know. I have no proof to back it up to say that it's true. Because they had like checkpoint, not checkpoints. I don't know what, like check-ins where you could go and like talk to people if you had any information. So before they had like the big tip line, like the FBI tip line and their own tip line set up, like right off the bat, the 13th and the 14th, and I believe the 15th, because I don't think the other one was set up until the 15th or 16th, but somebody will clarify that for me. But the first couple of days, it wasn't like fluid, which is how I think things kind of got all crazy. I heard Officer Skinner was the person that did the interview. Yeah, that doesn't, I mean, then by saying that, okay, the irony behind saying that is essentially saying that the PCA and every document attached to it from the search warrant and then till now is wrong and is full of lies, which is completely opposite of the people who want to put out there that Skinner is the one. See, this is where the whole debunking shit needs to come in. If Skinner is the one, why wouldn't they put Skinner in the PCA? Why would they hide that? Right. So it essentially, the people who are putting out that Thomas Skinner is the one that he talked to, in turn, are now calling law enforcement liars. Yet they're the ones who support law enforcement. It's very bizarre. There's no proof that he talked to anybody else. There's no reason to believe that he didn't talk to Dan Doolin, and that they would not. I don't. Yeah. The Frank's memo says it called the tip line. This is what I'm saying. They tell him, like, I think he calls in and says, yeah, I was there. There wasn't necessarily a tip line yet. This is why somebody's going to have to verify then. I'm going to do a whole, you know what? I was talking about this with some of my girlfriends the other day, that I just want to put together a whole thing of just the shit that's out there that there's no way it's true. That's where I'm at. It was announced on the 16th. Thank you, all eyes on Delphi. Chat's going kind of fast, so I might be missing it. I might be missing some stuff. The Frank memo said they called tip line. He came forward. It's bad to you that he didn't continue to come forward. Did anyone else there that day come forward multiple times? Well, ironically, there's lots of rumors. Ironically, one of the people who was there that day was at the police station that night and didn't come forward to say she saw anything until years later. So he went and told them he was on the bridge. How many times does he need to tell them? I think that the bigger question about him coming forward was during the press conference where Carter is saying, we're looking for this unidentified, car at the abandoned CP CPS building. You know, the one where he once again misspeaks, because that seems to be what Carter does a lot. And then they have to come out the next day to clarify what he actually meant. And he says they're looking for the abandoned car, remember? And then they have to come out the next day and be like, no, we weren't talking about an actual abandoned car. We were talking about the abandoned CPS building in a car that was there. So now people are like, well, if Richard Allen knew they were looking for an abandoned car, you know, a car that was parked at the abandoned CPS building, why didn't he come forward and say that was his car? That's what the whole thing is. And, you know, and then they also say we're looking for the owner of that vehicle that was parked there between the hours of 12 and 5. Now, that covers Richard Allen's time that he says he was there, and covers the time that Liggett says that Richard Allen was there. So why didn't he come forward and say that? I'll need so much memory for that. What was Doolin looking for 5 years? His memory? Well, my biggest issue with Doolin is, here's my thought. This is my thought. Take it for what you want. My thought is that all the initial reports or tips, or however you want to refer to it, all those people who came forward within those like first couple of days saying like, hey, I was here, or hey, I think I saw this, or hey, whatever, they all got compiled, put into the system, and then closed out. Because for years, Sergeant Kim Riley, Tobe Lesenby, Carter, they kept making the statement, we think we already talked to this person. Like they knew that something had happened with the tip system at the beginning of it. They knew that there had been some fuck up that screwed up anybody being able to follow up with anybody or something like that. And that's when they're like, oh, wait a minute. We think we talked to this person. Every one of them kept saying that over and over again. So it's always made me think there was some big screw up at the beginning and tips were lost, tips were misfiled, that they knew that. Because otherwise, why would they continue to say that they thought they'd already talked to the person? I mean, and shit, let's be real. Tobe Lesenby goes into the CVS and interacts with Richard Allen over the years. And he never realizes that he's Bridge Guy. Tobe Lesenby's talking to him in CVS. Let me see. Thanks for joining, Missy. Mark and Indy. If I'm 100% innocent, I'm not coming. Shit, why is it? It's just like clicking around. I'm not coming forward and voluntarily saying anything to Ellie. If Ellie finds me, I'm still not saying anything without an attorney present, even if I'm completely innocent. I'm with you. I don't care what it is. You want to come and talk to me, then I want an attorney. I am too, what do they call it? Not biased isn't the right word, but now that's stuck in my head because of everything we talked about. Why didn't Dan Doolin come forward again if R.A. told him to his face he was on the same trail around the same time as Libby and Abby? Well, that's always been my issue since this came out, is Dan Doolin on the stage on the 22nd where they're having the press conference, and he doesn't say, wait a minute. I know that guy. I talked to that guy. Was there a public request for info on news channels or anything? You know, the ones you see that say if you were at around X or area, Ellie is requesting to. I don't know if it went out on the news. I know that on the 13th, the family members were on the news. The news was there. So I don't know if there was a public request for info right off the bat. There was, did I save that? Is it this one? Let me see if it's this. So on the 13th, they're talking about to not have people go out and search. As our FD and law enforcement officers continue to search, please do not hinder their efforts. If an organized search party is formed, we will let you know. Let our responders do what they do best. Please don't go out to the search on your own. You could become part of the incident, and we don't want anyone to get hurt and take away from the search efforts. Very common. So I don't know if there was another one that I don't have that's something along those lines. Yes, Teresa, thank you very much. And that's the point that I'm referring to when Carter announced, we are looking for this person. Please come out. Yeah. Well, I mean, okay. I obviously have no idea what Richard Allen was thinking at the time, but I can think that I would go, well, they already know about me, so they're not talking about me. They already know about me. I already told them everything about me. So if they would already know that it's me if that's who they were talking about. So I don't need to go forward again. That's kind of what I think like I would do if I was that was my situation. Obviously, I'm not him, so I can't tell you why he did or didn't do something. But I just think for me, I'd be like, well, I already talked to the guys. I already told them where I was. I already said I was parked at the old Farm Bureau building. It depends on how many interviews he did, in my opinion, and how fast they were, Ivy. That's true. Can we please clarify that the witnesses listed on the charging document is not the same as the state's witnesses? It's literally just a list of people that they included in the PCA. That's literally it. Yes, we will do that. Absolutely. Because that's one of the things I wanted to talk about, why I have him up. RL completely changed his appearance, quit wearing a fanny pack, quit wearing his cam hat, got a haircut, etc. It's called stubborn. Yeah, the recording was also lost. My big question on that was, all the recordings lost, or was it just Richard Allen's recording that was lost? That's a big thing for me. I don't know that, though. I don't know that it was Richard Allen that parked there, because how do you trust what Betsy Blair says and then say, sorry, Betsy Blair, we think that you're lying about the car? Because she says that she saw the Ford, you can't see my quotations, but the Ford Comet. Right. The three girls that ended up being four instead of three. Like, it was impossible that he could have possibly seen another group of three. They're looking for a person at the CPS, told them she saw a car parked there, but she described a 1960s Mercury Comet, not a 2016 Ford Focus. Exactly. Well, then you have the guy that was driving by who says that it was a purple PT Cruiser or small SUV. Then you have the other guy driving by who says it was a smart car. So that's why you don't get a car description. That's why they don't tell you a car description, because they can't. They can't tell you a car's description because all their witnesses essentially see a different car. But I mean, PT Cruiser, small SUV, smart car? I mean, smart car, is the guy saying a smart car like the little tiny smart cars? Is he saying Betsy Blair did, Angela? Same one who saw the Comet. And she said, I know it was a Comet because it reminded me of my dad's car when I was younger. Very big difference. Very big difference in that kind of car compared to what the other one saw. And she said the car was not black. Well, then you have the other witness who says his eyes were not blue. Well, this is, I mean, like I said, eyewitnesses are notoriously not, they're not good. Yeah, he saw a totally different car that was parked out on 300 North. It wasn't even in the parking lot. It was parked outside. He said he's not the only one who saw it when he was working there. Okay. I just question where some of this obvious misinformation has come from. You and me both, Janie Lane. You and me both. I was asked, like, does debunking any of that stuff matter? And I was like, well, Yes and no, because I mean, if you can narrow down where all the information comes from, is that important? But then it's like we end up in the whole like the leak of the matter. What the wheat? Okay, hold on. Now I've lost all my stuff. Oh, here. Okay, we don't need this one up anymore. We don't need this one up anymore. And we don't need this one up anymore. So let's go through. Ooh, you know what? There was something I wanted to point out here, though. Maybe it wasn't. Let's go through the motion for leave to file amended charges and what this means. Oh, that is so small for you guys. Who said it was parked on the side of the road in between the CPS building and the bridge at 207. That it had been there. That's the same. Yeah, same guy that went on. And I'm pretty sure that's Brad Heath. There was the picture that was put out on social media saying, I think I saw the guy. He was sitting at the park. But it was like a different park. It wasn't even the same place, I don't think. But they thought that it was him, so they posted it to see if anybody would recognize him. I keep hearing this whole, the reason I wanted to talk about this again, even though, like I said, we touched on it the day that they dropped, but then we went back to talking about the Supreme Court stuff. So I want to go through it a little bit slower, so because I just keep hearing some things that I'm like, it's not true. So state's motion for leave to amend the charging information. Once again, I've already stated it, but I'm going to say it again real quick, is that this is a request for him to amend the charges. This is not abnormal. The timing of this is what I consider abnormal. Prosecutors will file to amend charges up until the day of trial. Typically, it's changing charges or reducing charges, but amending them is not unheard of. So don't take this wrong. It's the timing of him doing this that I find absolutely suspicious. Yes, 2 separate groups of girls, 2 separate groups. There was the group of 3 earlier in the day, and then the group of 4 later in the day. What happened to the jet ski? I want to know about the jet ski. Still not sold on anything to do with this motorcycle. I'm not convinced of it. I know that there are people that are. I'm just not. Not there. Not there with anything to do with the motorcycle. But we'll see. Okay, so on October 28th, 2022, the state filed a charging information alleging these offenses: murder as outlined in count 1 and murder as outlined in count 2. The defendant was arrested on October 26, 2022 by a detective with the Carroll County Sheriff's Department. The probable cause affidavit executed by then detective, now Sheriff Tony Liggett, and filed by the state on October 28th identifies acts of murder on or about February 13th. The discovery in this cause also revolves around acts of murder occurring in Carroll County on that date. The charging information and the probable cause in this matter reflect the charge of murder under the murder code with the 2. This is always important. Commonly referred to as felony murder. Specifically that Richard Allen did kidnap victim 1 and victim 2 by force, and in the process of committing that felony, both victim 1 and victim 2 were murdered. Okay? So they charged him with 2 counts of felony murder. The state hereby moves to amend the charging information to add the additional counts, which include murder under the 1 for both victim 1 and victim 2, along with a kidnapping charge. Now, we'll go back through this because I still think that's the type of vote. It is what it is. Under the kidnapping charge and for both victim 1 and victim 2. There were 2 charges. There are now 6. 2 felony murder, 2 murder, I call murder 1 because of the 1, and then in other states it's just murder in the first degree, like murder 1. Indiana, the way that they have it written, is a little bit different. So then a kidnapping charge for each of them. So there's 6 charges, 3 for each girl. Okay. The state is asking the court for leave to file these amended charges because the charges more accurately aligns the charging information with the cause's discovery and probable cause affidavit. Because of the clarity of the discovery and probable cause affidavit, the defendant has been on notice since the beginning of this case. So a big thing that keeps coming out now is that there's new evidence. That there's new evidence of what... Oh, I wish Bob had it left. I'll have to ask him this on his live. If there was new evidence, there would be a new probable cause affidavit. So it's not new evidence that has been found now and the reason that they're changing the charges. He's asking for those charges to be amended based on the cause's discovery and the probable cause affidavit from the beginning. He's essentially saying what we have and what we already knew about actually fits these 6 charges better than it fit the other 2 charges, or just the other 2 charges. So that's a great point. So I just, no new evidence. And I keep hearing that in a lot of different places, like, well, they must have new evidence if they're going to up the charges. But Nick McClelland is telling us there is no new evidence because he's not writing a new probable cause affidavit in support of new evidence. Does that make sense? So I just want to clarify that for everybody, because there's not new evidence. He's saying this is everything we already know, everything we knew then, and then we told him at the very beginning, which is why I was going to bring this up. Just got to find it. Figure out where the hell it was in here. They don't title it 1 there, but there is another document that they do title it 1, and I don't remember which one it is now. I will find it though to show you. So what they're saying is that from the beginning they told him that this was a possibility of him being charged with all of these, like they were able to charge him with murder 1. Clarity of discovery, yeah. So everything they already compiled shows that Richard Allen actually killed the girls, is what they're saying. They would have to have a new for the judge to file new charges. New charges. They would have to have a new probable cause affidavit with new evidence that supports that. What he's saying is, we don't need to do that because we believe, the state of Indiana, Nick McClelland, believes that with everything we already have in the clarity of discovery and the probable cause affidavit we already wrote, that there is enough to substantiate the amended charges. We don't need to give you a new one because we already have that. Correct. They can request to. They can't just do it all willy-nilly, but they can request to. Yes. The judges normally approve it. We'd have to sit here and go through like old case law and say who did and who didn't approve things like that. But it's normally it's normally not a big deal. Like I said, they'll do it up until trial. It's just the timing of this one that makes it the most interesting. But what about the results from old evidence? So all of that would have already been when McClelland, so when they filed in October for a discovery deadline, McClelland says, yeah, well, we've given them everything that we have. We've given them everything that we have, and now we want the defense to also have a discovery deadline where they have to give us everything they have. So anything that was still pending, we never got the hearing. We never got to actually see that all unfold. But anything that would have still been pending would have been discussed in court. Like, hey, we still have this piece of, or I'll say, well, we still have this one sweatshirt it's being held, up by the lab because of whatever reason. And as soon as we get the results of that test, we'll send that over. And then typically the judge would be like, okay, well, you need to get on the lab. You need to get on the lab and get them moving because they've already had this much time, so on and so forth. Does that make sense? Right. Well, it's also going to be for the judge to say, yes, you do, or no, you don't have the evidence based on what you are submitting as having the evidence. The chart aligns with the original charging information. The original charging information and the probable cause affidavit. They think that it's okay to amend the charges based on that. So just don't get caught up on the fact that there's this, brand new evidence that is now here that they think they already have. Now they're like, oh, look, we can get him. No, this is most likely. Now we're going to go into my opinion here. My opinion is, no new PCA, no new evidence. New charges mean little to nothing. At this point, it's just pure bullshit. I mean, you want to summarize it like that? Yes, I agree. I believe so. There's a few people that are stating that this means that there is a plea deal in the works. I disagree. This to me means that they are looking to make a plea deal, and by upping the charges gives them the ability to plead down to one of the other charges, plead down to the charge of just the felony murder, where it wasn't a death penalty or a life in prison. Because that's the difference here, is what the sentencing is on these. And when we were looking up before, remember, it was like 45 to 65 years. But then the other one is the one that they can give the death penalty on. So I'm gonna finish reading. I think did I already finish this one? That this amendment does not substantially change the state's theory of the case. This amendment does not prejudice the defendant's substantial rights. The state is asking for court to amend the charges because the charges are more accurately aligns with the charging information and the probable cause affidavit. I think those are two big things that you guys have to remember. He just wants to change it based on what they already had, not any bombshell new stuff. A plea would be pointless because he would still die in prison, but a plea would be good for Nick McClelland. And now you have, remember, he brought on in October the special prosecutor to help him with the case, which I'm still going to swear he should have done that from the get-go. He's not experienced in this kind of trial, and he should have had somebody there to help him. And we probably would have seen charges like this from the beginning, because that's typically what they do. And that's why a lot of states like to keep the death penalty, and not necessarily because they want to put people to death all the time, but because they want to use it as a bargaining tool. One of the things in Colorado, when they decided to go, because they had the death penalty and then they took it off the table, when the prosecutors were arguing in front of the court about why they should keep it, the number one reason was because it's a tool for plea bargaining. People don't want the death penalty; they don't want to die, so they end up going, accepting a lesser charge. So it makes more sense that they charge him with more stuff so that they can get him to come down. Now, my opinion is There is no way in the world that Andrew Baldwin and Brad Rosie went through all of this to get back on the case to help him take a plea deal that any competent defense attorney could do. I just don't see that. It makes no sense to me. I do not foresee a plea deal. I mean, shit, stuff surprises me, but that's where I'm at. I do not foresee a plea deal. I do not think that these two attorneys are like, okay, we're back, let's get you a good plea. I'm just not there. I think they added 2 of the charges because they know they don't have a case against RA and are going to say that RA might have given his gun to someone who committed the crime. Right, but they also have him saying that he didn't let anybody use his gun, so. Well, no, because he's the ex-mayor is taking on the other cases when Nick is now going to be in trials like this. Not in the way you think, though. That's the problem. He didn't go to the prosecutor and say, "Hey, I did this. Let me just get a good deal out of it." That's not really how that all went down. So, yeah, I think that's exactly what they're hoping. I also think that the second part of this is, say he doesn't take the plea deal, which, like I said, I don't think that he will. They go to the jury and they say, okay, these are the options. The elements of each crime is different. So by proving any of these crimes, he can be found not guilty on one and still guilty on the other. But if you only give them the one option, you have to be able to prove all the elements of that crime. So the chances of a conviction when you have more charges is better. Does that kind of make sense? Yeah, there's a process for a legit confession. I haven't heard the confession, but it does hurt his case. I don't disagree, but at this point, we don't even know if they're going to, there's so many questions. We don't even know if they're going to allow anything like that to come up. I'm going to go ahead and take a good guess here that Judge Gull would. But somebody else brought up to me a good point, and they were like, how is, the defense team is going to say that he was incompetent and, mentally wasn't in the right place, and that's why he makes these confessions. But then in turn, that same defense team says that he is competent enough to say that he wants them as the attorneys. And I thought, okay, that's a valid point, right? And I was like, okay, let's look at that the opposite direction then. You're going to say, the prosecutor is going to say that he was of his sound mind and when he made the confessions, but not of his sound mind when he decided that he wanted to have these attorneys on. So, I mean, it goes both ways. And I think that if we continue to look at things like that, then it washes. So that's kind of where I'm at with it. Yeah, Frank's the one who sent me that. Yep. That's where I'm kind of stuck with it. It's like, if you go the other way, then you can't have it both ways there either. Now, they talk about like the mental health records. Well, they can't give up the mental health records because of HIPAA. But if they keep using the mental health to push the narrative that he needs to be moved, she's not going to have much choice but to bring something forward to prove that they're either right or wrong. And that's what she kind of told them the last time that they brought it forward, was like, I'm denying this motion for prosecution to have access to his mental health records. But if you keep pushing the issue, then I'm not going to have a choice but to give something. Like, there's got to be something else to it. So here's the other part. If he's incompetent, then he needs to be evaluated and deemed incompetent. And then a lot of that stuff kind of goes away. But the point is that they believe him being in prison is affecting his mental health to the point where it's causing the incompetence, or it will cause the incompetence. Yes, you can. Absolutely. False confessions happen all the time. People will say, well, false confessions are typically to police. Well, maybe I'll do a video on that. So I wrote this report on false confessions. And one of the things that it talks about when people confess to family members is that they do it. There's a couple of reasons behind why they do it. They do it because they want their story to be what the family member believes, number one. And the other reason was because they want the family member to go on. They want them to just go on with their life and stop living, stop, like, it stops the cycle of them being frozen in time while this person is in jail or prison or wherever else. So it gets them to leave and gets them to go. Now, is that the case? I don't know, but I'm just saying that those are things that when I had to do the research, that's what the research says. It is a possibility. Well, they're not claiming incompetence. So that's why I was like, you can go back and forth with it. You can go either way. If he were incompetent, he would have been evaluated and declared incompetent, and there would be a stay until he gets well. Correct. So I think that's what she was basically telling them, was like, if you're going to keep pushing this, then we're going to have to go a different route. Well, so we don't know what we haven't heard them. We haven't heard these confessions, but essentially what we're being told, or what was said in the courtroom in June, was they were very generic. Now, generic is, it's my fault. It's, it's not direct. It's not like, I killed the girls, I did this, I did that. Generic is more, but we don't know. Now, generic is a generic word, so yeah, I don't think so either. The Odin face tattoo mafia. Well, in fairness, the Rockaways, Randy Jones didn't get the face tattoo until he was no longer allowed to wear the patches. Okay. So before we finish up, I want to talk about what Kara had to say. So, because obviously she is an attorney. So I have a lot of respect for her and Mark. And then, obviously, you guys know I have a lot of respect for Bob, but he's also an attorney in Illinois. So it'll be nice if he has Shay on tonight, in my opinion, or whatever. She's a tyrant. I agree. There's something going on with this, man. I mean, I just don't know how people just let's just sweep it under the rug. This is all totally normal. Like, none of this is normal. Okay, can you guys see this? Okay, let's blow it up a little bit more. Ooh, that might be too much. Oh, you guys can see that. Okay. So reviewing the new charges in the Delphi case. 30 minutes before the Indiana Supreme Court began hearing oral arguments in Richard Allen's second original action on the removal of attorneys Andrew Baldwin and Brad Rosie, the Carroll County prosecutor requested to amend the charging information. I was only able to review the amended charges quickly after they were filed. Since then, I have been able to review them fully and thought I would share what I discovered. In Indiana, we have both knowing intentional murder, which is the 1. Are you leaving, Noe? Okay, I'll see you later. The knowing intentional murder and felony murder, which is the 2. Unlike other states, Indiana treats these two types of murder the same. They are defined under the same statute and carry the same potential penalties, 45 to 65 years in prison. Subsection 1 of Indiana's murder statute, the 1, is murder as most people commonly know it, the knowing or intentional killing of another person, which is why I call it like murder 1. Allen was not originally charged with knowing intentional murder. Rather, he was originally charged under subsection 2. To prove felony murder under that subsection, the state must prove that a defendant killed another person while committing or attempting to commit one of the enumerated offenses. Kidnapping is one of those offenses. The original 2 charges against Allen that were filed in late October 2022 were for felony murder of victims 1 and victim 2, where the underlying felony was kidnapping. To obtain a conviction for felony murder, the prosecutor does not have to prove that the defendant knowingly or intentionally killed the victim he kidnapped. Rather, the prosecutor need only prove that the defendant knowingly kidnapped or attempted to kidnap the victim, and that during the kidnapping or attempted kidnapping, the victim died. Essentially, the intent to commit the kidnapping is also used to satisfy the intent to commit the murder. In the amended charges, the Carroll County prosecutor added a statutory citation to the original counts 1 and 2. Under Indiana law, a defendant can be found guilty of a crime under 2 theories of liability: principal liability and accomplice liability. Okay, this is important. One is liable as a principal if he himself committed the offense in question, under Indiana Code section 354124, which we talked about this when we were like, wait a minute, why are they adding that on there? Like that's weird. They're saying he's the accomplice, yet they're saying that he did it. One is guilty as an accomplice if he knowingly or intentionally aided, induced, or caused another person to commit that offense, regardless of whether that person has been prosecuted, convicted, or acquitted of that offense. So essentially, what they're saying is, like, under like the felony murder, even though if he's not the one that did it, if he is the one that did it, you can get him on the murder one, right? You can get him what I call murder one, which is the first code, intentionally and knowingly, or you can get him under the sleepy goosey. Of course you did. On the felony, you would get him for the kidnapping that results in the girls dying, right? Now, this one is essentially stating that he can be an accomplice at the same time. And she's saying that you can have principal liability and accomplice liability. You can be found guilty under both theories. Well, I'm okay with that. I don't even know, here, I don't want to get too far into the Nick stuff, but that's not even my primary concern is how, once we get there, once we're there, I mean, I don't know. That's where I'm at. How did we get there? How many shenanigans happened before we even got there? I mean, because if you think about it, that's going to take me totally off track, but I'm going to say it anyway. If you think about it, remember Nick McClelland tells the defense team, he says, I don't think we're ever going to be able to figure out who that professor was. They can't find the interview, so on and so forth, da 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 da. And he like puts that out to the defense team, like, I'm so sorry, we don't know who the professor is. And then all of a sudden, here comes Holman and Liggett and that whole crew, and they're like, Jeffrey Turco, we did talk to him. We talked to him recently, and make Nick look like a fucking idiot. So I don't know. That's where I'm at. Anyway, so you can be found guilty under 2 theories of liability. That is so interesting to me. So one is guilty as an accomplice if he knowingly or intentionally aided, induced, or caused another person to commit that offense, regardless of whether that person has been prosecuted, convicted, or acquitted of that offense. So we kept trying to say, like, they kept talking about like the other bad actors. Hi, NorCal Jim, good to see you. These other bad actors. And so everybody was like, they're charging him with felony murder, essentially telling the public he kidnapped them, but isn't necessarily the one that killed them, and that there's somebody else out there. And we talked about this on the lives, and I'm like, if it ends up being that way, and he goes to court, goes to trial, he's found guilty of felony murder, and they don't prove he actually killed the girls, people are going to be like, what the heck? But then who actually killed the girls? And then everybody's like, well, what makes you say that they can't prove he killed the girls? And I'm like, well, if they could go to court and say that and prove that he killed the girls, he'd be charged with the first one. And now he is. So this is going to, I mean, like I said, it's interesting. I just did not realize that you could do both and say, okay, now here's your other bad actors part. Bring in your other bad actors. We don't have to arrest them. We don't have to prosecute them. We don't have to acquit them. We don't have to anything with them. So public, shut up, because even though we think there might be other bad actors, it doesn't matter, and we're going after this one. That's what that is. Yes. Yes. No, essentially, we could have thought that there was a murderer on the loose if they only stuck to the original charge of felony murder and went to court and only proved that he kidnapped them. The world would be like, then who killed them? Even if the prosecutor and law enforcement thinks it was him, if they don't prove it in the courtroom, then people are still going to wonder who did it. And so that's why I was saying, like, so then everybody was like, why wouldn't they? Why do you feel like they couldn't prove it? I'm like, because if they could, they would have charged him differently. I feel for Abby and Libby's family. It's fucking chaos. And I mean, they've lived in chaos now for so long. So that's part of my frustrating part, and why people get so mad and they're like, oh my gosh, you're like so pro Richard Allen. And I'm like, I'm not. I have no skin in the game whether Richard Allen's the bad guy or not. And I just don't know if he is. I don't have a one way or another way that I feel about it. But I do have an issue with the legalities and the constitutional procedures not going right. Because guess what's going to happen? All these people who are like, throw Richard Allen in prison and let him burn and all this stuff, they're, in my opinion, I'm like, you guys don't care about the families, because by having all of these things happen with the defense attorneys, with Judge Gull, what we're setting up is legitimate appeals that the families who these people claim to care so much about are going to have to relive over and over and over and over again. So it's not because I don't care about the families, it's because I do. I do. My only communication with him has ever been involving the crime scene photos, and I only ever discussed what I was aware of regarding that. Nothing more. I'm just sharing my experience. And I think that's how it should be. I think there's a big difference between like colluding and we're all like, we work for the prosecution or we work for the defense. Besides, if you're just giving the information to the proper people and you walk away and you go, okay, I'm done. That's it. I did what I was supposed to do. I think it's the involvement, the deep-seated involvement in the case that becomes a bigger issue. Well, that's always been my question. That's always been my question. Yes and no. So I don't want this to go the wrong way, because I do. There's a difference between somebody turning in information to the people that it needs to be turned into versus somebody who's colluding with one side or the other. And I don't want those things to be convoluted because of everything else that's happened. That's sending in a tip to the right people or to the right person is what's necessary. Now, talking to that person and going out and doing any type of public shilling, we'll just say that, is much different. So don't convolute the two and take and make everybody into the same bucket. It's not the same bucket. They're very different buckets, because we don't want people to stop turning in information that is important by saying that they're doing something that they're not doing. So just remember, they're very, very different things. Okay, so let's finish reading, because she's breaking it down for us, which I am so thankful for. One is guilty as an accomplice if he knowingly or intentionally aided, induced, or caused another person to commit that offense, regardless of whether that person has been prosecuted, convicted, or acquitted of that offense. The amended charging information for counts 1 and 2 merely adds the theory of accomplice liability to the original felony murder counts. This is a theory of liability, not an essential element of a criminal offense. This is where it gets messy because of how everything is, written in the law. So it did not need to be added to the charging information. When the original charges of felony murder were filed against Richard Allen under Indiana law, he could be prosecuted for those offenses as either the principal or as an accomplice. Counts 3 through 6 of the amended charging information are new. Counts 3 and 4 allege that Richard Allen knowingly or intentionally killed victims 1 and 2, and these two counts also include a citation to Indiana's accomplice liability statute. So Allen could be found guilty of these offenses if he is proven to be the actual killer or merely an accomplice to the actual killer. Now, counts 5 and 6 allege that Richard Allen, while armed with a handgun, knowingly or intentionally removed victims 1 and 2 from the bridge to a wooded area through the use of force or threat of force. These kidnapping offenses are level 3 felonies, which carries a range of 3 to 16 years in prison. Counts 5 and 6 include a citation to Indiana's accomplice liability statute. So break it down. Allen can be found guilty of these offenses if it's proven that he is the one who kidnapped the girls, and or if he merely aided, induced, or caused another to kidnap the girls. This is an either or, not a one of. On the original counts of felony murder, the state was required to prove both the kidnapping and the killing in order to carry its burden under the felony murder statute. And the prosecutor is not required to plead accomplice liability in the charging information. So why the amended charges? One can really only speculate, but based on my criminal law experience, there are a few possibilities. I haven't read this far, so this is new to me. First, the kidnapping counts. Without the amended charges, theoretically, the jury could find that Allen kidnapped the victims but played no role in the murder. Okay, there we go. Absent counts 5 and 6. Allen would walk free. The state would be increasing its chances of getting some convictions rather than none at all. Well, perfectly said. As for the murder counts themselves, this is more puzzling. One idea is to increase the maximum possible sentence Allen could receive if convicted. By separating the murder and the kidnapping of each victim into separate counts, the 2 counts for each victim could be stacked or run consecutively. Instead of a maximum possible sentence of 65 years for felony murder, Allen could face up to 81 years in prison. Amending the charging information for this reason seems implausible. However, Allen is facing 45 to 60 years for each victim if he is convicted of felony murder. That's 90 to 130 years in prison. As the trial court could stack the sentences since there are 2 victims. Given Allen's age, this is a de facto life sentence. Seeking a longer sentence is pointless. Doesn't always matter, they still do it. But many have theorized this request to amend the charging information was done to file a notice of intent to seek the death penalty against Richard Allen. This too seems unlikely. To seek the death penalty in Indiana, a prosecutor must allege and prove the existence of one or more aggravating circumstances. The existence of at least one aggravating circumstance has been present since the inception of this case. If the state intended to seek the death penalty, why now and not earlier? That was my question too. It made no sense. This theory seems far-fetched. The timing of the filing would certainly raise suspicion. God, this is why I just love her. Plus, if the prosecutor wished to seek the death penalty, he would likely have filed the notice of intent when he requested to amend the charges. My best guess as to why the amendment. These charges likely should have been filed at the beginning of this case, and this amendment corrects the oversight. I also think it's a bargaining tool. And I think that this has a lot to do with the fact that you have the special prosecutor on the case now, who now has had the ability to sit back, relax, look at all that they already had. Because remember, it's not new evidence. It's everything they already had, and go, wait a minute. This should be the charges. And this way we can do this, that, the other. We can maneuver it this way. We can maneuver it that way. We can use it for a plea deal. We can get him at least on this, that, however. I'm going to go back to if there wasn't the issues that had arisen in October with the issues that recently arisen. They weren't removed. They filed the 70-day in November like they said they were going to do. We would have been at trial on January 8th. The whole theory behind why all of this happened was because many people, not everybody, many people believed that Nick McClelland was not ready. Does this prove that Nick McClelland was not ready when he wants to amend charges, which essentially would be 10 days after the trial would have already started? That's where I'm at. That's where I'm at. Time to review. Yep. He was like, okay, let's button this down. We're going to go this way, this way, this way. I'm like, to me, it kind of proves that he wasn't ready. Now, does that mean that there were shenanigans? I don't know if there's any way to prove it. So that's going to continuously just be something that people speculate about, unless, you know, one of them decides to write a book later and be like, oh yeah, I totally colluded with the judge, and or she does it, she's like, yeah, I was totally on the prosecution side. Like that's never going to happen. So we're never going to know the truth. It's always just going to be something that's in the back of your mind. And if it's in the back of your mind, then you have the perception of bias, which is a problem. And you should not have a judge that has so much perception of bias as somebody who's ruling over the case, when literally the first thing she does, we're sitting here going, what the fuck? Okay, so here, or does this mean further investigation to date has not implicated anyone else for the actual unaliving? Did RA's admissions show personal knowledge of the unaliving? Well, if you think about it, if those admissions happened that way, they happened in April. So we can go to the same conversation of why wasn't it done earlier based on that. And I know that the confessions they're not a big deal. So I don't want to say that they're not a big deal, but there's things about confessions, and I try to tell you guys, like, I could walk into a police station right now and say I killed my neighbors. They're not going to arrest me. They could probably detain me for a little while to check out what, my info, but they're not going to arrest me. They have to go and have evidence that supports that. So me just saying like it's my fault, and I don't know what he said. So but something quote unquote generic, there has to be something to back that up. They can't, so they wouldn't have amended charges on a generic one. And if it wasn't generic, they could have and should have amended the charges back in April. So that's where I'm at with it. He's a big baby. Ellie proved shit for the warrant. Nick didn't prove shit for the arrest. Gull accepted Nick's pinky promise about the guards. Liggett lied. The warden, guards, and Gull don't give a fuck. So here's my thought. I do think that there was probably enough for them to get the warrant, even with all the other stuff out. Like, I'm just, the threshold isn't as big. It's like, you want to go search it, okay, like go search it. You have a very, very small amount that you have to show the judge as your reason. So, I mean, I don't even understand the lies, but once again, that's not even what's important to me. What's important to me now is why she doesn't even care to figure out if it was true. She doesn't, like, it's not even whether it is true or not. It's the fact that the judge doesn't care to know if it's true or not. Just like she didn't care to know whether they were grossly negligent or not. Like, talk about not learning your lesson. Maybe you should actually sit down and go through everything. Just go through it. Just sit down, go through everything, and then make some decisions. It just doesn't make sense. The problem I have is I think Alan is guilty. I'm not convinced that he's not guilty. So please don't take it that way, because I literally, I could probably ask you guys 5 questions, and if you could prove to me those 5 questions, I would go one way or the other. But those are there's just certain things that I'm not there yet. I'm not sold, which if I was on a jury then leaves me with reasonable doubt. So you have to think of that too. So that those are the things that I would be looking for to go, okay, that's going to push me over from what I already know. Or maybe they have something completely different that I've not even thought about. And I'd be like, oh, shit, yeah, that. So Rosie should ask Gull a question about the Franks that she would only know if she'd read it. I thought that too. I was like, I wonder if they'd be like, so what did you think of us throwing Sleuthy Goosey in there and saying that she was there that day? What did you think of that? And then Gull's like, oh, I totally believe she was there. You know what I mean? And they're like, we never put Sleuthy Goosey in the Franks memo, you freaking liar. Obviously, none of that's ever going to happen. That's just me just talking. I have Apophis. What did I have Apophis say? Being the Purdue professor and bring the Purdue professor and let the jury decide who lied. And I think that's kind of what's going to end up happening. They're going to have to end up impeaching some of these people in front of the jury for them to understand what the difference is. And I mean, that's going to have to be part of their trial strategy. She really shouldn't fit into the Carroll County politics at all because she's from Allen County. But I mean, I think they're all tied together at some point because you're looking at your future aspirations of what you want to do with your life, you know? But you also have to remember, you know, what's his name? Diener went and signed a whole bunch of stuff for McClelland and then bounced. You know, he got Richard put into the DOC. He got all the search warrants. He got the probable cause after. He does all of that, and then he's like, okay, I can't do this case. Sorry. So maybe we'll see something like that with her. I doubt it. I just think that she is too bullheaded. She's too bullheaded. That's my thought. But you know, what does tomorrow bring? He said, I didn't sign up for this shit. Yeah, she wants to be on the Supreme Court. Absolutely. There's specific credentials too. So you can't, I mean, she can't just go into the trial. I guess she can. Fuck. I mean, I don't know what she's going to do. She can't just go in denying anything and everything that they do. It just doesn't. She also does agree in her order today. She does agree that the exhibits attached to, including the ballistics, they're good evidence that she's going to allow them in. You're not even going to go. She's like, I'm not even going to go to Indiana. My experts version, your experts, absolutely. And I'm telling, I always say too, like, experts in front of a jury, it really comes down to who is the easiest to understand and who they like better. That's what it's good. I mean, that's what it comes down to. All right. Well, I'm going to wrap it up. I think that we covered everything we wanted to cover tonight. I don't know. I just shake my head. I don't even know. This is why people don't ever leave this case. People don't ever leave. Hi, Ron Logan. I was buying fish. No, you weren't. It's been proven. We're not buying fish until later in the evening. Diener should have been made to have a hearing based upon his claims. Every judge has a responsibility to not be intimidated by their threats. Why do you think they collected an Aquafina bottle from the house during the search? DNA before they were able to actually obtain it. I think they wanted his DNA. Because if they took the Aquafina bottle from the search, then they could have it tested. Because remember, they search on the 13th, and then they don't have to, they could just run his DNA. He's not arrested yet. I think in Indiana, you get your DNA taken once you're arrested, or they can request a search warrant for your DNA. I think that's how it is in Indiana. Don't quote me on that, but I'm pretty sure that's what it is. So take the Aquafina bottle, because that's trash, and you're allowed to take that. So they obviously have DNA. I want to share something. Do you want to come up, Sleuthy? Okay, hold on. Do you want me to share it for you, or do you want to come up? I'll send you a link if you want to come up. Everything I've said, I think I'm pretty much done with my thoughts. Yeah, you can check out. Yeah, it's freaking the Hotel Delphi. Yeah, if she wants to, I'll send her the link. Or if she just wants me to share something, I'll do that too. I know that Bob said he's going live in like 15 minutes, so. It's still no match. Sleuthy, you want to come up, or you want me to share something? Hey, sweet Melissa. If you want just to I can share this. Just like a Twitter guru. Okay, I'm just going to share it then. Let me see. All right, Twitter. Let me come back to you guys now. Okay, let's blow this bad boy up. Probably bad choice of words. I shouldn't say that. Okay, so Nicholas says, the first thing Judge Gull does after Alan gets his attorneys back is denying motions. Gull isn't going anywhere, and she will do anything short of putting a bullet in Mr. Allen herself to make sure he dies in prison. Okay, so you posted, Judge Gull went from not having read the entire Frank's memorandum to denying it, and the motion to suppress immediately following and Rosie resubmitting their appearances. I'm waiting for the official order itself to hit my inbox. The motion in limine regarding ballistics was also denied without a hearing that she'd had in her possession for months. Oh, it shows 850. Okay. Stuck in the Delphi vortex. Yeah, nobody wants to miss Bob's. I just can't wrap my mind around it. I just can't. I cannot make sense of why she just she's not in tune with the fact of what she's doing. Welcome to hell, Delphi, Indiana. Such a lovely place. Such a lovely face. It was funny though, because I think it was Charmaine that was saying like you know the song like surprise, 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 surprise. Like we didn't all know that was exactly what she was gonna do, or something freaking crazy. All right, I'm gonna wrap it up. Bob is starting in about 20 minutes. I know his link has been dropped a whole bunch of times, so go ahead. I'm back, baby. Were you not? Did you have to leave? You just came back as just in time to be serenaded. All right, I'm going to go. I will see you guys over at Bob's in about 20 minutes. Bring your questions so that he can answer. Or he's having Shay on, who's an attorney in Indiana. So that'll also be very, very helpful. Hey, forfeits. Last I remember, the motions are already granted, and we were just waiting on hearings. Now they are completely denied. Yep. Just done. Just done. All right. Thank you, everybody. I will see you guys tomorrow. You know, I appreciate each and every one of you for being here. You have 1,000 other places that you could be, and you choose to spend your time with me. I will never understand it, but I appreciate it so, so much. I'll see you guys in a little bit over at Bob's. Have a good one.